criminal damage. We will start off first with English law. And for the offence of criminal damage, we are going to look at Section 1 of the Criminal Damage Act. And there are three offences. There's subsection 1, criminal damage, subsection 2, where is the dangerous criminal damage, and subsection 3 will be on arson. Let's start first with the basic offence of criminal damage under Section 1, subsection 1. This is the definition for criminal damage, and let's break it up. Let's look and see what are the elements of actus reus and mens rea. So here are the elements, right? A person who without lawful excuse either destroys or damages property belonging to another, right? So that's the actus reus, destroy or damage property belonging to another with the intention to destroy or damage the property, or was reckless as to whether the property would be destroyed or damaged. So it is pretty straightforward, actually, the offence of criminal damage. Let's first look at what it means to destroy or damage. Now, is destroy something the same as damaging it? Well, no, right? Damaging it implies that it is not as bad as or serious as destroying a property. Now, the definition of what amounts to a damage can be found in the case of Morphitis and Salmon, right? This was a case where the property that was involved was some scaffolding clips, and there were scratches on it, so there was allegation that it was property that was damaged. Now, the court said that to define what damage is, you have to ask whether has the usefulness or the value of the property been impaired. So for the scaffolding clip, which was meant to be used in very harsh circumstances, it is expected for the clips to be scratched. So therefore, it was not considered to be damaged because the usefulness of it still, usefulness of it was not impaired, it can still be used, and the value of it is still maintained. It still can be used as the property, so it wasn't thrown away, and therefore it is not considered to have been damaged. So the key thing to ask about is to see whether property has been damaged or not, is to ask whether has its usefulness been impaired, right, or has its value been impaired. Now, what if it's a temporary impairment of the usefulness or the value? Will it still be considered to be damaged, or must it be permanent impairment of the usefulness or the value? We look at a couple of cases, the case of Hartman and the case of Crown against A. In the case of Hartman, a person painted something onto the onto the public area, public space, where he used water-soluble paint, right, which basically can be washed away with water, right? So it was not something that was permanent, it was something temporary. However, he was held to have committed damage to property because efforts must be made, right? Must be taken in order to wash away what he did. So therefore, it was considered to be damaging property. Compare that with Crown against A. This was a case where the accused spit onto a policeman's coat. So it was held then that the usefulness and the value of the coat has not been impaired, and it could easily have been washed off. Unlike Hartman, where money and effort had to be used to wash off what the accused had done. Now, damaging something doesn't necessarily mean that it has got to be broken also. Right? We're going to look at three cases, Henderson and Bentley, case of Tacey, and the case of Drake. In the case of Henderson and Bentley, it was held by just putting rubbish onto a place like that, it can be considered to be damaging it because the usefulness or the value of it has been impaired. In the case of Tacey, it involves a knitting machine like the one you can see in the picture, right? Where a part of this machine was removed, right? It was taken away, and therefore the whole machine could not be used at all. So therefore, it's considered to have been damaged or even destroyed because its usefulness has clearly been impaired. There's an interesting case of Drake, though, about whether can this be considered to be criminal damage or not when you clamp a person's car tire, because then the usefulness of the car has been impaired, but not permanently, but temporarily, but the usefulness of it had been impaired. However, in this case, the court held that it does not amount to criminal damage because the clamp can be easily removed. Suppose you compare that in the case of Hartman, where effort and money must be used in order to wash off what the accused has painted. Here, the clamp can be removed very easily, so the car was not considered to be damaged. Next, we will look at property, and property is defined under Section 10 of the Criminal Damage Act. And if you look at the definition of property, it's very similar to the definition of property under the Theft Act. So we're talking about property of tangible nature, right? Whether real or personal, including money, and talks about wild creatures which have been tamed or not, and talk about mushrooms growing wild or any plants growing wild, right? So basically, the definition is quite similar to what we have seen under Theft Act. And again, for belonging to another, defined under Section 10, subsection 2, you will see that it's also quite similar to the definition in Theft Act about belonging to another, where it's considered to be belonging to another if the person is in control of it or is in possession of it or custody of it or have propriety right or interest over it or have a charge on it. Now you see that section 1 starts off with saying that a person must, without lawful excuse, so he must have destroyed or damaged property belonging to another without lawful excuse. And lawful excuse is actually provided for under section 5 of the Criminal Damage Act, where it is provided that a person is said to have lawful excuse if he damaged or destroyed property having consent from the owner, or if he destroyed or damaged property to protect other property, right? So both of these are found in section 5, subsection 2, and we'll be looking at them individually. So first lawful, the first lawful, sorry, the first lawful excuse, which is found under section 5, subsection 2a, is belief in consent and is provided for that if at the time of the act or acts he believed that the person or persons whom he believed to be entitled to consent to the destruction or damage had in fact so consented, right? So as long as at the time when he destroyed or damaged the property, he believed, so again very subjective, just like in Theft Act, that the people to whom is entitled to consent to the destruction or damage had in fact so consented. Doesn't matter that in fact the people, these such people do not actually consent to it, but what matters is that the accused believe that they had so consented. Now this was raised in the case of Blake, where he actually wrote some Bible verses or quotation onto the wall, causing basically it's graffiti, right? And as a defense, he said that God told him to do it, right? And God owns everything, so therefore God consented to him doing it. Now his argument, of course, was not accepted, right? His argument was not accepted. The court said that this was something that they were not in a position to decide on whether did God actually consent to it or not, right? Now, the second part of 5.2a is that, or if you believe that the person would have so consented to it if they had known of the destruction and damage and its circumstances. So 5 subsection 3 emphasizes the honest belief. It doesn't have to be a reasonable belief, doesn't have to be justified. Now 5.2b talks about if it destroys property in protection of other property, right? In order to protect either property that belongs to himself or a right or interest in property which was or which he believed to be vested in himself or another, and he believed that the property was in fact in need of protection, right, at the time of the act, and that the means that he used were reasonable, having regard to all the circumstances. Okay, so he had to destroy certain property or damage certain property in order to protect some other property, and that some other property was in immediate need of protection, and that the methods that he used was reasonable in those circumstances. And in the case of Ashford and Smith, this was a case where they broke into a army camp, right, in order to protest against nuclear weapons, against war and against nuclear weapons. So they are saying that yes, we cut through the fence, we caused damage to it, but it was actually in order to protect the property of everybody in the world, because if there's a nuclear war, then all this property, everybody's property will be destroyed. But the court questioned about the link between cutting the fence and ensuring that there's no nuclear war, right? So the court just basically did not accept the argument. The property was not in immediate need of protection, and clearly the means that were used were not reasonable. Perhaps an example would be in this news report on the 16th October 2016, where there was a theme park at Komta which caught on fire. And if we look further down, you'll see that where it was stated that they had to tear down several wall structures to put out the blaze. So what they did was that they actually had to destroy certain of the wall structures in order to protect the entire building from burning down. So this was a classic example where there was an immediate need of protection, and the means that they used was reasonable in the circumstances. Right? So you see, the key thing is that it was done in order to protect the property, not like in Ashford Smith, where it was done in not so much in order to protect the property, and also that the property was in immediate need of protection. Right. So that's the actus reus for section one, subsection one. The mens rea, as we have seen earlier on, is pretty straightforward. It's intention to cause the damage or destruction. So the person intended to do that, or the person was reckless as to whether damage or destruction was caused. Now moving on to subsection 2 of section 1, dangerous damage. Right? If this subsection 2 is quite similar, but there are few additions. Right? So the key thing here, you will note that is property belonging to himself is also included now, and there's a further intention, right? A further mens rea, if intending or being reckless by the destruction or damage to endanger the life of another. So not just the person causes destruction or damage, the person must have intended or was reckless that the destruction or damage would endanger the life of the other, right? The destruction or damage must endanger the life of the other, of another. Having says that dangerous criminal damage is basically criminal damage plus the two provisos plus an additional requirement for intention and recklessness. Okay, proviso 1 is that it applies to the own property, and proviso 2, section 5, does not apply. And then the additional intention and recklessness is to endanger the life of another by the destruction or damage. Now, it's key to note that the life must be endangered by the destruction or damage, all right, and not by the means of causing the destruction or damage. So, in order to understand that, let's look at the House of Lords case of Steele, where the accused shot through a glass window, damaging the glass window, and the bullet narrowly missed the victim. So in this case, the accused was charged with dangerous criminal damage because he caused damage to the window and at the same time endangered the life of the person behind the window. Now the House law says that it doesn't fall under dangerous criminal damage, right? Because for it to fall under dangerous criminal damage, the endangering of life must be by the destruction or damage to the property. Here, the damage to the property is the window, right? Damage to the window. But the accused's life was not endangered. Sorry, the victim's life was not endangered because of the damage to the window. Do you see that? right? His life was not endangered due to the damage to the window. His life was endangered because of the bullet that was shot by the accused. So for it to fall under section 1 subsection 2, the life must be endangered by the damage or the destruction of the property. Let's look at cases which has helped to 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 show to this point. Right, two cases heard together by the Court of Appeal, Webster and Warwick. In the case of Webster, the accused was on a overhead bridge and threw something into an oncoming train, right, causing the uh, causing the ceiling fiberglass to break, and it rained down onto the passengers and endangered the life of the passengers. In the case of Warwick, where the accused threw a stone or a brick to the back windscreen of a police car, and the and the window was broken, and the glass fell into the passengers in the car. Now, in these two cases, the life of the people in the train or in the car were endangered because of the destruction or the damage, because of the damage that was caused, right? Not because of the stones that were thrown to break the glass, right? Or to cause the damage of the top of the train, but it's true because the roof of the train was damaged or the windscreen was damaged or broken or destroyed. And this destruction caused the glass to fall onto the passengers into the vehicle, and therefore it endangered their lives. And finally, for arson, 1 subsection 3, it is basically where the destruction or damage of property was done by fire, right? Any offense which was done in 1 or 1 2, where the destruction or damage of property was by fire, then it should be considered to be arson. Now, do look at sections 2 also about the offense of threatening to destroy or damage property. It's also an offense where he intends that the other would fear that it will be carried out. Right? So he makes the threat intending that the other would fear that it will be carried out to destroy or damage property. And section 3, possession of anything with intent to destroy or damage property. So here is again intending to use it or to cause or permit another to use it to destroy or damage property. Okay, so for offences under 1 subsection 2 and 3, it'll be maximum life imprisonment. For any other offences, it'll be maximum 10 years. Right, so section 1.1, person without lawful excuse destroy or damage property belonging to another with the intention or was reckless as to destroying or damaging the property. Right, the key thing will be morphitis and salmon, where the usefulness or the value of the property has been impaired, and therefore that we consider to be damaging that property. 1.2 is where the damage or the destruction endangers the life of another, and 1.3 is where the damage or the destruction was caused by fire. The defense to 1.1 would be if the person believed you have the consent, or you believe that it was acting to protect other property. So moving on to Malaysian law now, we will talk about the offense of mischief under section 425 of the Penal Code.